Reeves Immigration Law Group now brings you immigration law on your side.
Alright, magandang gabi mga kababayan and welcome to another episode ng ating Immigration Law on Your Side. Kuya Yo, galing po sa Las Vegas, Nevada, and si Attorney Diza, nakikita niyo sa screen, galing po sa San Francisco, California. He's coming in via Zoom. Pag-uusapan po natin ngayon, immigration options for a fiancé K-1 visa holder who divorces before getting married. Mukhang walang forever ito ang pag-uusapan natin ngayong araw na ito. So tumutok mga kababayan, because in one of our episodes here at Immigration Law on Your Side, we actually discussed the process and limitations of the K-1 fiancé visa, di po ba? Well, it is intended for U.S. citizens to be able to petition the love of their life for a non-immigrant K-1 visa to come to the United States and marry within 90 days, apply for a green card, and therefore live happily ever after. Kung merong forever nga, no? But kung wala, ang problema is paano kung hindi nag-work yung kanilang marriage. So with us tonight again is Atty Flomy Diza para bigyan tayo ng forever answers kung ano ang mga options for K-1 who divorces before obtaining their green card. Magandang gabi po sa iyo, Atty Diza.
Good evening, Kuya Johan, at sa viewers and listeners natin, magandang gabi sa inyong lahat at masaya at maganda ang ating pag-usapan dahil syempre involved dito ang K-1 or yung sabi mo nga love of their life or may forever ba or paano kung wala, di ba? Very interesting dahil marami sa ating mga kababayan ang nag-file ng K-1 fiancé petition para mapabilis actually ang pagdala sa kanila dito sa United States at makapiling at syempre mag-establish ng family.
That's
so,
right.
isa sa mga paraan ng mga kababayan natin na dalhin ang kanilang partner, no? Partner in the sense na either na hindi pa sila kasal or pwede rin, Kuya Johan, yung same-sex relationship, right? Lalong-lalo na walang marriage sa Pilipinas, there's a possibility of doing a K-1 sa the same-sex relationship. At paalalahanan din natin yung mga kababayan natin na kahit kayo po ay may divorce dito sa US or may divorce po kayo sa ibang bansa, right? Hindi nyo pwedeng pakasalan ang inyong partner sa Pilipinas kung wala kayong annulment. So kung divorce lang meron kayo, hindi po pwede. So the best way to bring your partner is through a fiancé. So there are many issues surrounding a fiancé visa at nabanggit mo nga kanina, Kuya Johan, ano yung mga options nila kung the marriage fell apart while waiting for the green card.
Attorney, backtrack tayo a little bit. Bigyan natin ng konting refresher ang ating mga kababayan regarding the K-1 visa. Ano po yung mga requirements para po mag-qualify ang isang beneficiary sa K-1 visa?
Yes, importante yan. Unang-una, the parties have previously met in person within 2 years. So tama yon na kailangan nag-meeting sila. Kahit sabihin mo pa, attorney, may anak na po kami, right? Malalaki na yung mga bata, pero yung last kong dumating ako dito sa Amerika 5 years ago at hindi pa ako bumabalik. Now, you cannot file a fiancé dahil one of the requirements is you need to meet in person within 2 years from the filing of your petition. So take note of the word in person din dahil lalong-lalo na ngayong especially during the COVID, Kuya Johan, maraming tatanong sa atin, pwede po ba na
Zoom
na lang, di ba? Virtual na lang at ramdam ko naman na siya talaga ang aking love of my life forever na, di ba? So hindi rin po pwede. Hindi rin po pwede ang virtual. It needs to be in person. So kailangan nyo ng proof yan na either plane tickets or may tatak po ang inyong passport that you have visited, yung fiancé mo abroad or kung saan man kayo nagkita. Now, pangalawa, that the parties have the bona fide intention to marry. Ibig sabihin, purpose nila yan na magpakasal at syempre this should be shown in one of the evidence when you file for that petition, Kuya Johan. It's going to be a brief statement of the relationship, right? How they met and how you fall in love and how the relationship developed from friendship to romantic, and of course yung intent nila should be stated there that they intend to marry 90 days from the arrival nung fiancé. Now, pangatlo, Kuya Johan, is they are legally able and actually willing to conclude a valid marriage in the US within 90 days after the fiancé's arrival. Ano ba ibig sabihin ng legally and actually willing to conclude a valid marriage? I mean, in the sense na, as we mentioned kanina, right, importante yan na if you were previously married, right, you need to have a valid termination of your previous marriage, right? Either, number one, divorce or annulment, pwede ring death ng spouse ninyo, right? So, yun yung mga tawag nito, yun yung mga proof that you are legally allowed to get married. Or single po kayo, wala po kayong prior marriage. So, yun po ang pangatlo, ano? And then, pang-apat, evidence of a valid relationship with the US citizen petitioner. So, hindi lang po pwede sabihin na, okay, nag-meet po kami, umuwi ako, and we met one time, at the airport, siyang sumundo sa akin, and that's it. So, you have to, document the relationship from the time you were introduced or you met, either through social media or yung mga dating apps, mga dating apps, dating sites rather, right? Siyempre, dandun sa statement ninyo, you can also provide those evidence of relationship, like, yung mga messages nyo together, that you're sending some gifts or balikbayan boxes or probably a remittance through Western Union, or ano pa ba, yung mga emails nyo with each other or messages nyo, and then also when you guys met in the Philippines or elsewhere, you have to show photographs or receipts that you stayed at in a hotel or dined in a restaurant. So yun yung mga evidence of a valid relationship, Kuya Johan. If you have children, and that's better kasi hindi naman, may pagkakaila, that's one of the best evidence of the relationship. So yun yung mga requirements ko yan. And also very important nga din pala, idagdag din natin sa requirement, would be the petitioner should be a US citizen. Kasi po, ang green card holder hindi pwede mag-file ng fiancé. Ang purpose ng fiancé po ay mas mabilis kasi pagka-file mo ng petition with USCIS at pag na-approve yan, it goes directly to the embassy for interview, right? Post-COVID po, usually ang mga interview natin, nakakakuha na tayo ng interview from 3 to 6 months from the time we file, mabilis lang ang interview yun. But during COVID until now, medyo may mga backlog pa rin sila, but it's still shorter process than marriage kasi yung sa marriage naman, yung I-130 petition, pag na-approve yun, right, it goes to the NVC. Yung NVC na yan collects yung mga fees and documents, right? Tagal din minsan yan dahil minsan nire-reject or minsan may kulang. So, yung sa pag-upload lang ng documents sa National Visa Center sometimes takes about 6 months to a year. So, yun ang nawawala na nakakat na process when you do the fiancé.
All right. Attorney, as with anything, immigration, may mga limitations. Marami sa ating mga kababayan ang tumawag sa atin and nagsend ng mga questions, but they were asking about the limitations of a K-1 visa.
Yes, ang K-1 visa is parang crewman yan, Kuya Johan, di ba? May mga specific limitations. Yung crewman, pag nag-jump ship ka, hindi ka rin pwede mag-adjust ng status, right? Unless you're 245I. Now, the same thing with a K-1. Yung K-1 naman, ang limitation niyan is you need to marry, right? And you need to marry your petitioner within 90 days. You need to file the adjustment, right, from the same petitioner, right, based on the approved K-1. So, that's the only way, right, for you to be able to get your green card. There's no other way, right? Unlike in a tourist visa or yung mga employment-based visa natin, ng mga H-1Bs or L-1s, E-2s, mga ganyan, right? So if they marry a US citizen, for example, and they file the adjustment of status and the marriage failed, right? Hindi na-go through yung relationship at, either they withdraw the application or na-deny, for whatever reason, right? And they marry another US citizen, and they can always do that, right? Even if they marry, after the divorce, and they will be able to obtain their green card through a subsequent marriage to a US citizen. Now, in a fiancé visa context, the only way, ulitin natin, for the applicant fiancé to get the green card is through the petitioner and nobody else. So, it's really hard for applicants to have other options, right? So minsan, okay yun, Kuya Johan, kung right the marriage work really well and nagkatuluyan sila and they have, as we mentioned kanina, live happily ever after, they have children, they're enjoying each other's company, sila pa rin mag-asawa. But there are situations where mga fiancé were stuck with their petitioner and it's hard for them to get out from the relationship because that's the only way for them to get the green card, right? But there are situations na talagang kung hindi naman may iwasan, right? And what I tell client is, if you think your life is in danger or very miserable ka na dyan sa asawa mo, I mean, we don't advise them to just keep holding on the relationship. Kasi di natin alam, lalo na kung violent yung asawa po ninyo, you need to get out of that marriage. And there are options that, for you to be able to still get your green card.
Kaya nga talaga parang malateleserye ito pagka pinag-uusapan ng fiancé visa, marami ang nag-react kaagad na ito pag-uusapan natin ngayon. Kaya attorney, at this point, we'll throw in some of the viewer questions to you para po masagot nyo kung ano yung pwedeng magawa nila. Isa sa mga viewers natin na nagtanong, sabi niya, attorney, I am a native and citizen of the Philippines. I met my future wife in 2017 when we were both studying medicine in the Philippines pala, no? So dun sila nagkita. She filed a petition for alien fiancé, form I-129F, on my behalf, which was approved by the USCIS. O, swerte naman. I was issued a K non-immigrant fiancé visa on February 14, 2018, and I was admitted to the United States as a fiancé for a 90-day period. The fiancé petitioner married, I and the fiancé petitioner married within 90 days. So tama, okay. We filed my adjustment of status after the marriage. Pero before the interview, attorney, ito ang nangyari. Sabi niya, my wife was physically and emotionally abusive and always threatening me to get deported. Isosoli sa Pilipinas. If I don't follow her wishes. She also said that she will not attend and cooperate at our interview sa immigration, siguro ito. So sabi niya dito, attorney, can I still get my green card if my wife refuses to cooperate?
Yes, maraming mga ganyang sitwasyon, and the answer to that question is generally yes or it depends. Isa sa mga requirements, Kuya Johan, for you to be able to get the green card is determination whether the relationship is legitimate or valid, right? Valid in the sense na hindi lang po kayo nagpakasal at meron kayong marriage certificate or marriage contract. That's not enough. You have to show documents showing relationship, meaning mayroon ba kayong mga joint accounts, joint taxes. Do you have the same residence, joint lease or lease contract, nandun ba kayo? May mga kaibigan ba kayo at kamag-anak na nagpapatunay na kayo mag-asawa? So yes, so even if, for example, you already file your adjustment, and of course that period of time where you're waiting for your actual green card, right? At sinabi mo nga na physically abusive or verbally abusive ang asawa po ninyo, and you think na it's hard for you to stay in a relationship with your wife or with your spouse, then you have to think kung ano yung next option nyo. And of course, number one is to document your relationship. Pangalawa, Kuya Johan, especially at this time where USCIS will just issue the green card without an interview. No? Okay tayo kung walang interview yan, right? So kahit hiwalay na kayo halimbawa, at nabigyan kayo ng green card, okay pa yon, okay ang green card po ninyo because you get married and you entered into a valid relationship. Pero yung tanong po ng ating viewer is, pwede pa ba siya makakuha ng green card kung hindi na co-cooperate ang asawa niya kung pinatawag sila ng interview, right? In a typical spousal, yung I-130 petition, right? Kung kayo pinatawag ng interview, kailangan nandun yung asawa na petitioner. Kasi kung hindi siya mag-show up, yung asawang US citizen, pwedeng i-deny ang inyong application, yung petition ng asawa sa adjustment based on abandonment. Di ba? Hindi nila pwedeng sabihin na kahit may anak kayo, hindi nag-show up yung petitioner mo, right? Pwedeng i-deny. But in a fiancé context, yung pinag-usapan natin ngayon at sa sitwasyon ng ating kababayan, nag-message sa atin, The answer is yes. Punta lang po kayo sa interview, kahit kayo lang mag-isa. And we just had a similar situation like very recently. And we went to the interview. We tell them that, the spouse, although they're still married and they're still together, ayaw ng asahang mag-cooperate. And, there's exactly like threatening words and physically, verbally abusive. May police report pa kami, right, to show na merong abuse, right? So we went to the interview, and as long as the affidavit of support is still there, right, pwede pang ma-approve yung application po ninyo, right? Pwede pang ma-approve ang application nyo. And it's really a good thing, Kuya Johan, because in the past, ang sinasabi ng immigration is hindi na pwede dahil wala na yung petitioner or hindi nagko-cooperate ng petitioner. But in a court decision, right, yung matter of cese, merong decision na yan, ang sinasabi, which is on point sa ating kaso ng ating viewer, the court says that as long as the fiancé entered the US on a valid K-1 and marry the petitioner and have filed the adjustment of status, so even the petitioner no longer cooperates in attending the interview, right? Pwede pang makuha ang green card ang aplikante just because they get married on time within 90 days and was able to establish that the relationship was valid and bona fide.
Nako, magandang information dyan sa ating mga kababayan attorney. Ito, tutuloy-tuloy ko na. Marami pang mga questions pumapasok sa ating dito sa PHLV Radio. Sabi dito, attorney, what if my husband already filed for a divorce and it was finalized? Na-finalize ng kanilang divorce before I received my green card. Anong solusyon dito, attorney?
Yeah, one of the requirements ng fiancé and the I-130 is a valid relationship at the time of adjudication. But as I mentioned kanina, the same thing, Kuya Johan, whether the divorce has been filed or not, whether the petitioner and beneficiary are still together, as long as ang requirement natin doon is there was a valid marriage, they got married, and then they can show that it was a valid relationship. And number 3, yung affidavit of support, di ba, ng ating kababayan, ng petitioner rather nandyan pa, then the immigration has no reason to deny the case. And incidentally, may mga clients din tayo na, of course, they want to be interviewed by themselves, right? And the petitioner no longer with them, and they presented, hey, I have the divorce. So then immigration, I don't know if they really went over the application form, denied the adjustment. So the applicant came to me, right, and said, attorney, I have a divorce and I have a denial. So what anong gagawin ko, di ba? Wala naman akong dinidate ngayon. No. And, gusto ko pa rin mag-stay sa US at mayroon akong magandang trabaho. Right? We filed a reconsideration on time. Like we said that the immigration committed an error in denying the application because we argued na ang applicant ay K-1. And under the matter of cese, yung pinag-usapan natin kanina na ang decision ng court is as long as they get married, and there's a valid relationship, this the affidavit support is still there, then the service should reopen the case and approve the adjustment. Now recently, we were able to get the reopening. Ni-reopen naman nila. In other words, they agree with our argument, and we're just waiting for either the issuance ng green card na or an interview. So exactly on point din yung isang question ng ating kababayan.
Yeah. Kasi tinatanong nila, attorney, ito sa isa pang question na pinadala ng ating mga viewers. What other options do I have daw? Sabi niya, if the petitioning wife has already withdrawn her affidavit of support. Ayan.
Yeah, medyo masaklap yan, Kuya Johan, because ang typical, rather ang regular na I-130, right, yung petition ng spouse. Let's say you get married, you entered as a student or as a employment or tourist visa na hindi ka K-1 pumasok, right? And then you get married here and then you file the I-130. It's not a K-1 adjustment or fiancé adjustment, but it's spousal adjustment. In that situation, Kuya Johan, usually ang affidavit support, di ba, pwede tayong humingi ng joint sponsor, right? If, for example, na-withdraw na yung affidavit support or hindi na feasible yung affidavit support dahil ayaw na ng petitioner. In a situation, in a fiancé aspect, Kuya Johan, the answer there is no. You can no longer, continue with the adjustment. Although there's still an argument, and we're still fighting, right? Ang ating USCIS, and of course there are issues that we raised sa USCIS and even sa mga district courts, arguing that the petitioner already filed an affidavit support at the K-1 stage. Now, if you remember, right before the interview at the embassy, the petitioner is required to provide yung I-134, di ba, yung affidavit support for a K-1, right? So on that aspect, but ang argument natin is hindi magiging public charge, kasi ang argument ng USCIS is pag wala ng affidavit support, ang aplikante is already subject to a public charge and therefore inadmissible siya, right? And then ang requirement pa ng batas is that in a K-1, ang kailangan manggagal ng affidavit support is from the petitioner lang. Hindi pwede sa iba, right? Sa ibang aplikante, ibang joint sponsor. So in that aspect, pag winidraw na yung affidavit support, right, as I mentioned, it's going to be hard for you to get the green card, although you can still consult with an attorney and fight the case and argue that you don't need an affidavit support, even if withdrawn, because the I-134 should serve as the affidavit support. Now, may hope pa ba yung kababayan natin na sumulot kanina, right? Yes, there's hope because you can always file yung I-360 naman, right? What we call the abuse spouse petition, right? Or what we call VAWA, right? Violence Against Women Act, or abuse spouse, where you can establish that you get married in good faith, that you entered, you have a lot of documents showing that this is a valid relationship, and siyempre importante rin i-document po ninyo that the US citizen spouse, like in our case kanina, you suffered extreme cruelty or battery from your US citizen spouse. So ang extreme cruelty and battery, Kuya Johan, right, at mga kababayan natin, hindi lang binubugbog po kayo ng asawa nyo, binabato kayo, or sinasaktan po kayo physically. It could also mean emotional abuse, psychological abuse, mental abuse. So lahat yan po pwede po yung i-document through your statement or through a psychiatrist, right, or through hospital records that you went to a hospital for treatment or for psychological evaluation dahil nade-depress na kayo dahil sa nangyayari sa inyo. So pwede po yun i-document, and even if the affidavit of support was withdrawn, you can still pursue your adjustment of status through Violence Against Women Act. So po pwede yan as an exception where the petitioner withdrew the affidavit of support.
Nako, maganda ang mga talakayan natin ngayon, and our audience is so engaged, and we thank you so much. Kung meron pa po kayong mga ibang mga questions, mangyari lamang pong i-comment ngayon, and even after the program, si Attorney Diza will be responding to those here at the comment section. Or you can also email us at info@phlvradio.com and we'll send it over to Attorney. Ito siguro, Attorney, isisingit ko pa itong isang question na ito. Sabi niya dito, there is no abuse from my spouse and have agreed to part ways and divorce. I found someone, okay ito I found someone I fell in love with again and have children. Can I adjust status in the United States by virtue of the new love, siguro, Attorney?
Well, the answer is no, just because of the limitations that we discussed, right? You can only apply for an adjustment of status through your petitioner fiancé.
Oh.
Right? So, hindi po pwede ang mag-adjust ng status dyan sa bagot po ninyong spouse. Even if your children, may mga anak po kayo, right, na 21 years old na, right, hindi rin po pwede. Or, for example, meron kayong employer, attorney, yung employer ko, registered nurse ako, pwede akong petitionin, right, or willing rather to petition for me. The answer is no, because of the manner of entry. And under Immigration and Nationality Act, again, the only way for you to adjust is through that marriage, through that petition. Either itinuloy ng spouse po ninyo, petitioner, to cooperate with the application, or you were subject to a battered spouse or extreme battery or cruelty from the U.S. citizen spouse. So the answer there is no, you cannot adjust status in the U.S.
Wow. Okay. So I'm sure marami gusto mag-follow up ito siguro, but you have to comment it here or send us a private message here at the program para masagot ni Attorney Diza. Juicy and mainit itong K-1 na pinag-uusapan natin. Even during the time, Attorney, na pinag-uusapan natin ito on its own as one of the alphabet soup, and ang daming nag-react talaga. Talagang maraming gustong magpa-petition as K-1. Attorney, lilinawin lang natin sa ating mga kababayan, itong K-1 is non-immigrant. Ano po, Attorney?
Yeah, K-1 is a non-immigrant. It's not an immigrant process. It's just a step for your fiancé. It's a process, right, for the fiancé to come to the United States. So it's a two-step process for you to get your green card. The K-1, which you're going to get it from the embassy, and once you're here, enter the U.S., marry your U.S. citizen, petitioner, and file the adjustment.
Tsaka kayo magkakaroon ng green card. Kaya pinag-uusapan natin yun ito. What happens if the marriage falls apart bago makuha nyo yung green card? Para po sa mga late tuners natin, mangyari lamang pong balikan ng ating episode ngayon, and we've been talking about immigration options for a fiancé or K-1 visa holder who divorces before getting the green card. May mga options. So balikan lamang itong episode na ito. Attorney, maraming salamat sa mga information mo regarding K-1. I'm sure this conversation will go on. But Attorney, before we end the program, itong sa immigration natin dito sa US, meron po bang mga updates tayo na pwede natin ma-share sa ating mga kababayan?
Yes, bago ko pala Kuya Johan, iliwanagan lang natin sa kababayan natin so I didn't respond right away to the last question.
Okay.
Right? Can that if you can go back to the last question where nag-asawa siya ulit ng panibagong US citizen, ano nang options niya? So he cannot adjust his status in the US. Ano nang gagawin natin, right? So if you cannot adjust his status in the US, ibig sabihin hindi ka lang pwede mag-adjust dito, hindi mo pa ang green card mo. Meron pa rin option sa inyo, right? Either the spousal abuse na pinag-usapan natin kanina or yung provisional waiver. Take note, there's also that option, right? Ang provisional waiver is for you since nag-overstay na po kayo sa US, right? Pwede kayong i-file ng I-130 nung subsequent spouse po ninyo, no? Yung US citizen ulit, right? I-file yung I-130 and then after it's got approved, it goes to the NVC and you inform the NVC that you're filing a provisional unlawful presence bar. And the reason for that is since you cannot adjust status in the US, ang kukunin mo, babalik ka sa Pilipinas para doon mo pick upin yung green card mo. Kasi nga, hindi ka pwede mag-adjust dito because of your entry as a K-1. So yung provisional waiver na yan, you have to file that with USCIS here habang nasa US po kayo. Di ba? Hindi pa kayo umaalis. So parang bago po kayo umalis, humingi ka na ng tawad na, meron akong asawang US citizen ngayon, I cannot adjust status in the US. And you have to prove that your US citizen spouse or parent, kung meron kayo, would suffer extreme hardship, right? And then, pag na-approve yan, it goes back to the NVC for the processing and hintayin mo yung interview sa embassy. Only then, pag nakakuha ka ng interview appointment, right, sa embassy, doon ka palang magpaplanong bumalik sa Pilipinas para sa medical exam mo and then interview mo. So once that you get that I-130 approval and 601A approval na napapatawad na yung 10-year bar mo, right? Kasi pag nag-depart ka or umalis ka, umuwi ka sa Pilipinas na walang 601A approval, 10-year bar po kayo dahil lalo, stay na kayo ng America for more than 1 year, right? Kasi kung hindi nag-go through yung marriage mo dun sa petitioner, di ba, you're supposed to go home. Pero if you did go home, find someone else and found the true love of your life, right? Nag-stay ka na dito, yun yung paraan. You can still do the 601A. It's a hard process, it's a difficult process, it's a longer process, but that's a way and the only way for you to get a status, right? It's better to have something, than nothing, kaysa naman naghintay ka ng wala, maghintay po kayo ng immigration reform na hindi naman nangyayari. So yun yung ating isa mga options natin. There are many ways, right? And there are many hopes for a K-1, fiancé applicant who divorces or even if they didn't get married. And then the situation, pwede tayong 601A. So those are the options, and of course it's really important sa mga kababayan natin, to consult an immigration attorney, right, to discuss the options. Hindi yung it's end of the world pag niwalay na po kayo ng inyong asawa. So having said that, Kuya Johan, you're talking about you're asking about the updates, right? Maraming nangyayari ngayon, right, sa ating immigration, lalong-lalo na sa border. Mga asylum applicants, andyan pa rin, right, yung prosecutorial discretion that we mentioned, right. We've been getting approvals for termination of cases from immigration judges and government lawyers. There's a long delay and backlog of cases sa immigration courts, but if your attorney is, does know how to handle your case, to either expedite the case or request to yung prosecutorial discretion to decide the case based on, the records, etc., right, or close the case, may mga paraan po yan at madaming mga paraan para po kayo ay mawala sa immigration court. Aside from that, may mga yung 5 years na banggit na natin sa last program natin, yung work authorization, Kuya Johan, marami tayong natatanggap ngayon, right? They're giving 5 years now. So even if marriage-based, asylum-based cases, right? Dati 1 year yan, dati naging 2 years, ngayon 5 years. So you have plenty of time to to work and you'll get back to your feet, financially habang hinintay po ninyo ang iyong green card.
Wow, all right. And as usual, attorney, they can follow you on your social media pages and also on the website of Reeves Immigration Law Group, or they can call you. Mga kababayan, yung pong number ni Attorney Diza sa kanyang office sa San Francisco, nakikita nyo po sa screen, 415-568-3777. Attorney, meron po bang iba pang mga events na gusto nyong imbitahan ng ating mga kababayan?
Well, unang-una, maraming salamat Kuya Johan at PHLV Radio. We're here to render public service. We're open, several offices in the US, one in Makati and one in China. You're consulting with an immigration specialist. Ang law firm namin, Kuya Johan, we've been here for over 40 years na, right? And most of us are immigration specialists. Lahat ng klaseng immigration, we handle all those kind of cases, J-1 waivers. Right, we just recently have an approval for the P3. Di pa natin didiscuss yan. Right, wow. It's an entertainer cultural visa. Right, yung mga sikat sa Pilipinas, let's say they form a group and perform a variety show in the US. Right, alam ko marami na tayong mga US citizen artists, Filipino artists na nandito na. Right, kagaya ni Martin Rivera o Jaya, and na mayroong mga green card or may mga US citizen na sila. But people who are also popular in the US, who wants to come to the US and perform, right? Yung P3 may approval na po tayo dyan. So if you're interested, contact us. Yung perm na pinag-usapan natin din, recently Kuya Johan, we also received an approval for a caregiver. So our firm handles all this kind of immigration cases, right? And the good thing about it is this is just what we do. This is what we are good at and great at in dealing with your immigration concerns. Again, Kuya Johan, that's it. And every first Friday of the month, right, from 10:30 to 12 and 1 to 3 o'clock, Philippine Consulate General in San Francisco, there's the IBP California, nagbibigay po ng legal advice sa mga kababayan natin tungkol sa US laws, batas ng Amerika at batas po ng Pilipinas, ay nagbibigay po kami ng free legal services. Marami pong salamat ulit at I'll see you next time.
All right, maraming salamat Attorney Diza, at nabanggit nyo yung IBP. Shout out na rin sa lahat ng mga kasamahan nyo dito po sa IBP dito sa United States. Maraming salamat po sa inyong public service that you're rendering at the consulate ng San Francisco. So Attorney, maraming salamat once again. We want to thank you for the public service that Reeves Immigration Law Group has been extending to our kababayans, not just here in the United States, but very valuable information para sa mga kababayang nasa Pilipinas and all over the world. So Attorney, malapit na ang Pasko at medyo malamig na, siguro mas malamig na dyan sa inyo, Attorney, sa San Francisco.
Malamig na, mga 60s, 70s na kuya yun, and it's a perfect weather, hindi siya mainit at hindi rin siya malamig na malamig.
Nako, ang sarap na siguro pumasyal sa San Francisco. Mga kababayan, kung magawi po kayo dyan sa may San Francisco, mangyari po lamang ay kontakin ang grupo ni Attorney Diza sa Reeves Immigration Law Group. Nako, pag dadaan kayo ng cable car dyan sa harap ng kanilang opisina. Napakaganda. So Attorney, maraming salamat. We will see you again next time, guys. And this is Immigration Law on Your Side on PHLV Radio. We will see you again next time.
Reeves Immigration Law Group has been representing immigrants for nearly 40 years. Reeves Immigration Law Group has been fighting for its clients through experience and expertise. With immigration lawyers you can access at reasonable fees, even on Saturday. Payment plans are also available. Call us for your immigration solutions. We can do worldwide telephone and Skype consultations. Reeves Immigration Law Group, 1-800-795-8009. Reeves Immigration Law Group has offices in Los Angeles, San Francisco, China, and Philippines. See us at www.rreeves.com. Reeves Immigration Law Group, 1-800-795-8009.
Reeves Immigration Law Group has just brought you Immigration Law on Your Side. Wednesdays, 7 p.m. Pacific on PHLV Radio.